Contracts. Consideration and other sources of contractual obligation. Elvis Presley offered to pay off the mortgage of his mother-in-law, but before he could make the payment, the king of rock and roll died. The mother-in-law brought a court action against his estate to enforce Elvis's promise and have the estate pay off her mortgage. But the court found that the offer was merely a promise of a gift. It was not supported by consideration, so was not enforceable in court. A contract was not formed, and Elvis's estate was not forced to deliver on his promise and pay off his mother-in-law's mortgage. The courts will not enforce a gratuitous promise of a gift, but the court will enforce a promise that's been bargained and paid for. This is the essence of consideration, and is an essential element in the formation of a binding contract. The currency used to pay for the promise can be anything of value. Anything of value to the promisee, or anything of value to the promisor. If Elvis had bargained and agreed to receive a single dollar, or an apple pie, in exchange for his promise, the court would likely have found that consideration was present and a contract was formed. As a general rule, both parties to a contract must pass consideration to the other party to form a contract. Something has to be bartered and traded by each side to form a binding contract. However, there are some promises lacking consideration that are enforceable in court. Historically, promises under seal were enforceable, but this is no longer relevant as we don't customarily use customized seal waxes on our documents today. We will learn that promises can be enforceable in court when they are relied upon by the promisee. We will also learn that the court will provide a remedy for unjust enrichment when there are no exchanges of promises involved. Consideration involves a party to an agreement giving something up, incurring some form of detriment. Consideration refers to some form of legal value. In legal terms, it's often defined as bargained for legal detriment. The parties struck a bargain that involved each party giving something up. Consideration is a promised action, or omission of action, that the promisee did not already have a pre-existing duty to undertake. Consideration can take the form of money, physical objects, or services paid in exchange. It can take the form of an undertaking not to take certain action, or refrain from asserting an existing right. A common fact pattern in a contract lawsuit involves a claim that the defendant failed to deliver on a promise. The question for the court often revolves around whether the defendant's promise was supported by consideration. Did the other party give something up in exchange? Did the plaintiff pay for the promise? If the promise under question was supported by consideration, the plaintiff wins, the defendant loses, and the promise is enforced by the court. We know that the court will enforce a contract, but it will not enforce a gift, even a conditional gift. If you go to the car lot and pick out a car, I will buy it for you, is an example of a conditional gift. If you mow my lawn, I will buy you a car, is an example of a contract. The difference between the two is the element of exchange. The contract involves an exchange that was bargained for. There is no bargained for exchange in the gift. A famous old fact pattern sums up well the detriment aspect of consideration. Grandfather writes to granddaughter, "I don't want you to work. If you give up working, I will pay you an allowance." Granddaughter gives up work, but grandfather fails to provide the allowance. Was this a gift or a contract? Was grandfather's promise supported by consideration? It was a contract, as the granddaughter incurred a detriment. Grandfather claimed he received nothing in the way of value, but the consideration was found in the fact that the granddaughter lost something of value when she gave up her job. Grandfather was in breach of contract when he failed to pay the allowance. Illusory promises are so named because they merely hold the illusion of a contract. For example, a promise of the form, "I will give you $10 if I feel like it," is purely illusory and will not be enforced as a contract. Truly illusory promises are not enforced by the court. A promise for a promise usually forms a contract. For example, a promise to sell acts as consideration for a promise to buy, and a promise to buy acts as consideration for a promise to sell. But when the promise is illusory, it can easily be retracted and does not form consideration. Illusory promises are generally not enforced in court. However, the ability to form binding contracts is so important that the court will try to find ways to enforce agreements and will interpret promises as being real whenever it can. For example, many contracts include satisfaction clauses, in which a promisor can refuse to pay if he isn't subjectively satisfied with the promisee's performance. Strictly speaking, this is an illusory promise, since the promisor has no actual legal burden to pay if he chooses not to. However, courts will generally imply in law that the promisor must act in good faith, and only reject the deal if he is genuinely dissatisfied. The courts will not investigate the adequacy of consideration. A mere peppercorn of consideration is sufficient to find a promise enforceable by the court, even a promise involving something of great value. As we will see in the slideshow on defenses against enforcement, if the barter involves an imbalance of power between the parties, the courts can find an agreement unconscionable and unenforceable when it shocks the conscience of the court. But a mere peppercorn of consideration is usually insufficient to shock the court's conscience, and virtually any contract involving any form of consideration will be enforced. Past acts do not constitute consideration, as they do not involve giving anything up at the time of the agreement. There is no current obligation or detriment provided to support the promise, so there's no consideration. As you passed your exams last semester, I will pay you $1,000. This is not enforceable. If you pass your exams next semester, I will pay you $1,000 is enforceable, as it involves a real bargain and exchange. A pre-existing duty is similar to an illusory promise and does not form consideration. Consideration is required to modify a contract, so any modification lacking consideration would be ineffective in forming a new contract. The UCC treats such situations differently, so we're focusing on the common law here. Under the UCC covering the sale of goods, modifications are valid if they're made in good faith. If you promise to pay me $100, I will deliver the boxes Monday. This does not form a contract when you've already been employed to provide the services of delivering the boxes on Monday. You have a pre-existing duty. You're delivering the boxes anyway, so you're offering nothing new in exchange for the $100. This is not a contract and is not enforceable in court. If you said, however, "I'm obliged to deliver before 5 p.m., but I can deliver before 8 a.m. if you pay me $100. This is not a pre-existing duty. It's a new promise and a new detriment, a new obligation, and it will act as consideration. An exception to this rule involves a change in situation. If you'd been employed to deliver the boxes on Monday, but there was a huge snowstorm Sunday night that was so severe as to excuse performance, then the second agreement to deliver on Monday for $100 would involve a new detriment, and will form a contract as the duty to deliver in such harsh conditions was not pre-existing. The courts have been more willing to hold promises to third parties, strangers to the original contract, as consideration. So if you'd been paid by A to deliver goods and A becomes insolvent, then your promise to B to deliver for $100 will be enforceable. Pre-existing duty situations often arise in the payment of debts. If the debt of $1,000 is due and payable, the creditor may offer to call the debt settled if the debtor pays $800 a day. However, this promise, this modification to the original contract, would not be enforceable for lack of consideration. It's not a legal detriment to pay $800 when owing $1,000, so there's no consideration and the promise is unenforceable. After receiving the $800, the creditor could then ask for the $200 remaining. There is an exception for early payment or payment of disputed debts. Paying before the debt is due involves a detriment, qualifies as consideration, so promises to pay of undue debts are contractual and enforceable. In reality, as we know, the courts will look for the merest peppercorn of consideration in order to interpret a promise as a contract. So these cases often involve searching for new duties or new detriments at the time the modification of the contract was made. Courts will enforce promises unsupported by consideration, but involving reasonable, foreseeable reliance. If the climber asks the rope holder to promise to hold the rope, and the rope holder agrees, there's no consideration, as the climber is offering nothing in return under these facts. The promise to hold the rope is unenforceable in court, as it's unsupported by consideration. However, when the promise is relied upon by the climber, and the reliance is reasonable and foreseeable, the promise will be enforced by the court under the principle of detrimental reliance, otherwise known as promissory estoppel. The promissor is estopped from avoiding his promise by the reasonable and foreseeable reliance of the promisee. Promises binding without consideration. In addition to promissory estoppel and reliance by the promisee, there are other situations in which a promise can be enforceable without consideration. The promise to pay a past debt that is no longer legally enforceable is binding without consideration if it's in writing. The promise to pay for services already received is enforceable in many situations. Under the UCC, a modification of a contract for the sale of goods does not require consideration. A guarantee, a promise to pay an existing debt of another person, is usually enforceable if it's in a writing that's signed by the guarantor and states that consideration has been paid for the guarantee.